Everyone, my name's Diane McDowell. I am not only a trainer, but I'm an HR business partner that has worked in drug-free workplace for the better part of the last 23 years. So Ohio voters spoke and marijuana legalization passed. There are a few things that Ohio employers need to know and understand. When we look at the language, it's important to recognize that nothing forces an employer to tolerate the use, possession, or distribution of marijuana, and therefore the employer policy stands. There are a few things that employers need to do. One, you've got to establish a policy. Your policy language has to be very specific, very tight. Two, you need to educate your staff. The buzz has begun. They are talking. I'm watching online as people are talking about the use of marijuana, celebrating. They must understand that you will continue to test, that the use of marijuana medicinally or recreationally is a violation of your drug-free workplace policy and the consequences that follow with that. Supervisor training is critical. At the end of the day, your supervisors are your eyes and ears in the workplace. They know what's going on. They know what your employees are talking about. They know all the ins and outs. And so you have to train your supervisors for reasonable suspicion. It's a critical moment to pause to teach them what impairment looks like and what to do in the event that someone is under the influence of anything. Whether they're under the influence of marijuana, alcohol, prescription pain medications, they present a danger in the workplace, and therefore supervisors have to know the steps they must take. Documenting, confirming, confronting the problem, and in doing so, how do we initiate reasonable suspicion testing the right way? That's a huge liability issue. And so it's important that they understand the steps, they understand the protocol. Testing is the most effective deterrent to use. And at the end of the day, the question becomes, do we still test? I've gotten that question about 6 times in the last 4 hours, and I'm going to tell you that your policy is a safety mechanism. Your policy is important. And your employees who are operating machinery, your employees who are driving tow motors, driving vehicles, they are safety sensitive employees. You must continue to test them because at the end of the day, impairment is problematic. Now, the other question becomes, how do we test? Do we continue to use the urine technology, which detects for 21 to 28 days? Do we move to saliva, which is a shorter duration test, 3 days? Or do we go with the new technology that is available that detects marijuana for as short as 3 hours? It is out there. I want to flip all of what I just said upside down because there is another layer to this, and that is that the DEA received recommendations from the Department of Health and Human Services and the FDA in the last 3 weeks. And their recommendation is that the DEA reschedule marijuana from a Schedule 1 to a Schedule 3 drug. What does that mean? It means, but there is medical intention, medical use for marijuana. Now, when it occurs, and I'm no longer saying if, I'm saying when it occurs, it is important for every employer to be able to pivot, be able to shift. Now, impairment is still going to be problematic. Impairment for prescription, impairment for alcohol, impairment for marijuana. Impairment is a safety issue that we have to guard against to ensure that our entire team is safe. And at the end of the day, it is our responsibility to make sure that safety in the workplace is our first priority. So when the DEA makes the change and they switch marijuana from a Schedule 1 to a Schedule 3 drug, it will change everything because it will be at that point a prescription. And so we have to look at all of the protocols. We have to look at impairments specifically. Policies have to be tight, and that becomes a critical element for the program. So one of the things I want to say is I will be hosting a master class, and it's a master class on the legalization of marijuana. It is 4 weeks long. We have an attorney that is going to join us, who is a labor attorney. He writes drug-free policy. He has defended employers in the state of Ohio. He is the smartest attorney I know. For some of my other attorney friends, don't be offended. I'm just saying this is the legal eagle, and he's going to be with us. The reasonable suspicion steps that need to be taken. And then week 4, it is all about testing. At the end of the day, it is our biggest deterrent. And so we're going to talk about the test technology. I will be sharing the decal, and I don't know if you can see this, but I'll put it up on the screen. And this is a decal that everyone that attends this session will get. It basically says marijuana won't work here, so that people walk up, they are going to apply for a position that they see that this is a drug-free workplace program and testing is part of the rules. So 4-week session, it is a master class. I'm going to put a link to that master class on this video. Again, seats are limited. Sign up now. When the seats are full, they're full. I can't open them back up because that is the cap for the number of seats we have. And so if you have questions, I'm available. We've studied the team. We've been doing the research. We've been huddling. We've been doing the whiteboard. You name it, we have been on it because we want to make sure that our clients are taken care of and that we've set the groundwork, that we've done the work ahead of time to make it easier on you on the back end. And so, again, that masterclass will open up, and I invite you to attend. If there's questions I can answer, please don't hesitate to reach out to me. Again, my name's Diane McDowell. I'd love to help you. I'd love to answer your questions, take care of you. Training is critical. It's important for your employees. It's important for your supervisors. But we want to also take care of the business. We want to make sure that your policy is tight, right, and ready. We want to make sure that we've updated the information with and for you. We're going to give you the language in the master class. If you want us to do it for you, call me. I will walk you through and talk through what that would take. But we are here to support you. We're here to support safety in the workplace and to ensure that our employees go home the same way that they came to us. I don't want the woulda, coulda, shouldas in the past. I don't want employers to feel like, man, if I hadn't allowed that, or if I had a policy in place, we could have prevented this injury or this death or these damages from occurring. We know that injuries will go up. We know the consequences will happen from this legislation. And at the end of the day, our job is to protect the workplace, protect our teams, and protect the business overall. Thanks so much for listening. Any comments are appreciated. Anything I can do, don't hesitate to let me know. Again, my name is Diane McDowell. Training Marbles is my company. I'm the founder of the business. I'm not only an HR business partner, I'm a trainer. And at the end of the day, we'd love to take care of you. We are ready to take care of you. Give us a call. Watch for the link. It will go up with the video itself. Have a great day. Take care. Bye.